Well, defense attorney Ryan Pacyga, and today I'm going to talk about a new law that the Minnesota Supreme Court put out on defense of another. But before I do, I'm going to tell you a story, all right? This is about maybe 15 years ago. I was in a trial in Minnesota, and what it involved was two brothers, an older brother and a younger brother. They were both teenagers at the time, and then a group of other people who were, teenagers in early 20s as well. And for whatever reason, this group of other people wanted to attack my client, the older brother's little brother. All right. And they had with them, I mean, it's almost out of a movie. They had clubs with them. I mean, where do you even get a club nowadays? But they had clubs with them, chains, some baseball bats, and I can't remember a couple other weapons with them. And for whatever reason, they wanted to come after this younger brother who was maybe 15 or so at the time. And they were about to attack him, and my client grabbed a bat that was laying on the grass nearby, and he's the older brother. He was maybe 19 at the time, and he picked up the bat and he swung it at the first guy that was coming at his little brother, and he hit the guy's arm and broke it, and then he hit him in the head as well. And the state then charged my client, the older brother, with first-degree criminal assault, which is a felony and carries many years of prison time if you're found guilty of that, of course. They allege great bodily harm. So we raised the defense of another. In many states, including Minnesota, you have a right not only to self-defense, but to defend other people who are in danger as well, and you can use reasonable force to do that. Well, the law in Minnesota, unless you're in your home for self-defense, is that you've got a duty to retreat if possible. And at the time, until this new case just came out a couple days ago here in Minnesota, it was unclear in Minnesota if when you're defending someone else, you also have a duty to retreat. And I was like, come on, you got to be kidding me, to the prosecutor. And I think the judge even ruled that the jury instructions at the time in that trial indicated that my client had a duty to retreat if possible. And I said that you can't have that, because how can you defend someone else and at the same time have the duty to retreat? If you've got a duty to retreat, then you can't be there to defend the very person that you have a right to defend otherwise. And this made no sense to me. Well, at any rate, thankfully, the jury found my client not guilty in that case because of defense of another. And they probably thought it was a little crazy that anybody would ever suggest that that my client or any defendant has a duty to retreat if they have a right to defend someone else. Okay, so this case that just came out, State versus Valdez, involved a situation. I won't go through all the facts, but basically it answered two questions under Minnesota law. Number one, does a defendant have a duty to retreat in order to defend someone else? And they answered clearly no, because it makes no sense, of course. I was surprised that our courts hadn't come to that answer that question sometime before now, but nonetheless, at least they got that right. That's good. It seems to me pretty obvious. I don't know what you think. I'd like to know what you think. But second, this is the more interesting part about it. They did say that in deciding whether or not the defendant has a right to protect this person in peril, okay, the person who's in danger, they did impose a duty on the defendant to basically determine whether or not the person in peril had the ability to retreat. And here was the part about it. It gets a little confusing. What they're saying is, okay, fine, you don't have to retreat to defend someone else, but part of your analysis on whether it's reasonable and reasonable force and reasonable to defend someone else is whether that person you're trying to protect could retreat or not. But what they said is, you, the defendant, I don't have to get into the mind of the person who was in danger to see whether they were thinking they could retreat or not. But from my own perspective, if I'm the defendant and I'm looking at this and trying to decide whether I can defend you or not or protect you or not, from my own shoes, based on what I'm seeing and what I'm hearing and what I'm knowing, I get to determine from that standpoint whether or not you have the ability, the person I'm trying to protect has the ability to retreat or not. So that can get a little confusing, but that's the law on it. They basically said that it would be impossible or really hard for the defendant to put themselves in the actual shoes of the person in danger to determine whether or not they had an ability to retreat, but rather through your own eyes, what you're seeing and experiencing and hearing, you can calculate whether or not they've got the ability to treat. The point of that is of course, if the person could easily retreat and not be in danger, and it's obvious to the defendant that that could have been done, then they're saying maybe you don't have a right to defend someone else. Of course, a lot of times it's a split-second decision, and you don't know maybe how fast they can run away or whether they can run away or whether if this person pulls a gun, they could always shoot them right in the back, right? If someone pulls a gun on someone, I think it's hard to find a reason why someone wouldn't have a right to protect them and defend another in that situation, because they can't wait for the person who pulls the gun all of a sudden to raise it and shoot. By then it's too late, right? So you might have to act real quick. And even trying to retreat from a gun for the person in peril wouldn't be enough, because if they get shot in the back of the head or back and through the heart or other parts, they could die anyway, right? So that's the new Valdez case. But I'm interested to know what you think about, not so much about the person's need to retreat. That the case said no, there's no need for that, right? Of course, I can't retreat and protect someone at the same time, but more so. Let's talk about this for a minute. If someone pulls a gun on someone and the other person isn't armed, if you're going to protect them, would it be reasonable for you, if you have a gun, to pull it out and shoot that person before waiting to see if they raise it up and point them? If they just pull it out and show it, is that enough for you to take out your own gun and shoot someone and eliminate that threat? Or do you think someone should have to wait until maybe the gun is pointed, or even worse, until they shoot once, of course? Let me know what you think about that, because that's an interesting issue in a case I have coming up. I'm Ryan Pacyga. I'm a criminal defense lawyer. You can find me at arrestedmn.com or call me at 612-339-5844.